welcome to this channel. In this episode, we will discuss the laws relating to surrogacy in India. Hope you will appreciate this video. With the change of the socio-economic condition, the mindset of the society is changing at pace. Apart from the socio-economic factors, the medical reasons have put the society to look in a different perspective. Surrogacy in the Indian society have put its imprint owing to the socio-economic and medical factors. In some cases, surrogacy been the boon to the couple's family. Surrogacy as defined as a practice whereby one woman bears and gives birth to a child for an intending couple. Surrogacy generally can be divided or separated in two halves on the basis of the procedure. 1. Traditional surrogacy and 2. Gestational surrogacy. In India, law recognizes gestational surrogacy. Surrogacy at all point of time viewed by the laws in India as a blessing for the society, for which the commodification or commercialization have been seen as black patches and always approve the altruistic surrogacy. Comparing to the first world countries or developed countries, the surrogacy expenses in India is much lower. So, the responsibility have been mounted up on the shoulder of the legal system. Indian laws looks towards surrogacy as a blessing for the couple who are unable for the multiple reasons for getting a child. At the same time, the laws does not want the misuse of the blessings by the way of exploitation of the women who are conceiving the child and the child taking birth by the way of surrogacy. Indian law is quite stringent in the matter of surrogacy because surrogacy may lead towards commodification. It affects in turn to the mental, psychological and physical stability of the child and the surrogate mother. So, the Indian law always approaches toward altruistic surrogacy. Indian society always acknowledges the notion of the law that benediction not to be turned into curse, either for the individual or for the society, for which the policy goes against commodification. Surrogacy started to take the legal shape during the early part of this century, as the concept revealed by the medical science is not very far off. The first stone was put in 2002 by the Indian Council for Medical Research (ICMR) to regulate the unethical practices. In 2005, the government has accepted the guideline for ICMR to regulate, supervise and facilitate the assisted reproductive technology procedure, thereby to restrain the unethical commercialization, sex determination, exploitation. In order to restrain, certain punishment and fine has been prescribed. The development of surrogacy law was furthered by the introduction of the Assisted Reproductive Technology Bill, ART Bill 2013, which deliberated towards the non-commercialization. This bill aims towards the non-commercialization of the surrogacy and also imposes restriction to the OCI, Overseas Citizen of India, couple having child, couple under live-in relation, homosexuals and other, but speaks for the benefits and security of the surrogated mother and child. Surrogacy Regulation Bill 2019. The bill of 2016 was lapsed due to the lapse of the parliament session and it introduced afresh in 2019. The core of this bill was regulating the person who can enter under the surrogacy, the time frame of 5 years after marriage and such couples suffering from infertility problem. Though much awaited, but more or less in a complete shape or form, the law has been enacted in 2021. It came in the name of Surrogacy Regulation Act of 2021. The key objective is to use the very blessings of the medical science for the betterment of the mankind. So the term altruistic surrogacy have been proposed in the Act, where legislature were deliberate enough to propose what costs have to be incurred by the party applying for surrogacy. The cost includes the medical and clinical expenses and insurance or protection expenses during pregnancy. IVF, in vitro treatment, has been recognized as a form of ART. The Act speaks about the eligibility of a couple opting for surrogacy. The conditions set out as a woman without uterus, or the uterus missing or removed by surgery. B. Pregnancy loss multiple times. C. Pregnancy not possible for other medical causes. And D. Failed to conceive after IVF. The surrogacy regulation rules of 2022 lighten towards the procedural functioning of the clinic, its staff, medical practitioners, its experience and education, procedure to be followed in ART, and procedure to be followed for receiving permission of the proposed couple, and registration and cancellation of the clinics. The key points of the Surrogacy Act are as follows. 1. Egg donation is not permissible. 2. Only married couple can contract for surrogacy, but their marriage have to complete 5 years. Limitation. 3. Either one of the married couple have to be proven infertile. 4. Commercialization is banned. Only altruistic surrogacy allowed. Surrogate mother have to be the relative of the couple. 5. OCI, single, NRI, homogeneous couple cannot apply for surrogacy. 6. Age limitation for the male, female and surrogate mother has been prescribed. Surrogate mother must have to have a child of her own before surrogacy, and she cannot surrogate more than once. 7. Couple having child cannot opt for surrogacy, but if the child is mentally or physically retarded, then only can opt for surrogacy. 8. To obtain certificate from National Surrogacy Board or State Surrogacy Board before surrogacy. 9. In case of abortion of the surrogate mother, Medical Termination of Pregnancy Act 1971 need to be followed. And last, 10. After the birth of the child, there should be an order from the judicial magistrate for parentage and custody of the child. Though the Act seems to be complete, so far the objective of altruistic approach towards surrogacy, but lacking in some aspects, in question of fundamental right to privacy, as discussed in the Puttaswamy case. The court's approach is that to obtain certificate from National Surrogacy Board or State Surrogacy Board abridge the right of privacy of an individual in question. One's infertility is too private to oneself. The parameters set out in the Act so far of a surrogate mother may not be possible for all couples, which collide with the reproductive right under Article 21, and also the right of a single man or a woman to have a child, which goes or runs with the fundamental rights. All these need to be addressed in the future days. We are looking forward to it. As the Act is newborn, in the coming time, the courts will throw light on various aspects in the future cases. We have to be vigilant on legal developments ahead. The Indian judiciary fined the first case on surrogacy was Baby Manji Yamada versus Union of India and another, Supreme Court 2008. 2. Shuchitra Srivastava and another versus Chandigarh Administration, Supreme Court 2009. Another case which is pending before the Delhi High Court, Karan Balraj Mehta and another versus Union of India 2022.